Marcus is driving home on the 405 when the lights flash in his rearview mirror. He pulls over, hands on the wheel. The officer approaches and starts asking questions. And then he says the words that make Marcus's stomach drop. Step out of the vehicle. The cop claims he can smell something. Cops find drugs in your car or claim they did, and your entire life can flip in 60 seconds. What you say and what you don't say in that moment will determine whether you walk away or get arrested. I've defended hundreds of drug cases in California courts. Here's exactly what you need to know. My name is Dmitry Gurovich. I've been a criminal defense attorney for 30 years. Handling drug cases in both state and federal courts across California is what I do. And I can tell you without any hesitation that the number one thing that hurts people in drug cases is not the drugs themselves. It is what people say in the first 5 minutes after that officer walks up to their window. So let's go through this the right way. When can cops actually search your car? First, you need to understand when the police can actually have the legal right to search your vehicle, because they will always act as if they do, and that's simply not true. There are 4 situations where police can legally search your car in California. Number 1, you give them consent. This is the most common one, and it's the one that most people don't realize they're agreeing to. When the officer says, "You mind if I take a look?" and you say, "Yeah, sure, go ahead," or you just step out without objecting, you have just consented to that search. You gave them permission, and now anything they find is coming in as evidence. Number 2, probable cause. This means the officer has specific, articulable facts that suggest criminal activity beyond just a hunch. Something visible, something specific, not "you seem nervous." Number 3, plain view. If the officer can see drugs or paraphernalia from outside of your window without entering your vehicle, those are fair game. If there's a pipe sitting in your passenger seat, that's in plain view. He doesn't need your permission for that. Number 4, search incident to arrest. If you get arrested, even for something unrelated to drugs, officers can search the immediate area around you and under certain conditions, your vehicle. These are the 4 scenarios. And the one that gets people in trouble 90% of the time is number 1, consent. Keep that in mind. Now, what about the marijuana pretext in California? This is something very specific to California, and it matters a lot right now. California legalized recreational marijuana in 2016 under Prop 64. That means the odor of marijuana alone is no longer automatically sufficient to establish probable cause to search your vehicle. For years, officers would walk up to a car and say, "I can smell marijuana," and use that claim as justification to tear the vehicle apart. Now, courts in California have been pushing back on this. If marijuana is legal to possess in small amounts, the argument goes, what exactly does the smell tell you? It might tell you that someone smoked absolutely legally. It might tell you nothing at all. This doesn't mean that the argument is dead, right? The smell argument. Officers still use it, prosecutors still argue it, but it is far weaker than it used to be. And if you did not consent to the search, your attorney can challenge it in court. The key point is, again, do not consent, ever, even if you have nothing in the car. Because the moment you consent, you have eliminated one of your best defenses. Now, here's what to say, right? What do you actually say? You say this calmly and clearly. I do not consent to a search. One more time. I do not consent to a search. That is the sentence. 5 words that absolutely matter. You don't have to explain why. You don't have to tell him what's in the car. You don't have to justify yourself. You simply do not consent. Now, here's what might happen next. The officer might say he doesn't need your consent. He might say he can smell something. He might call for a drug dog. He might tell you to step out of the vehicle. You comply with his lawful demands. You step out, but you keep your position clear. I do not consent to a search. If he searches anyway, that becomes a legal question for the courts. And that's exactly where you want it, in front of a judge, not on the shoulder of a freeway where you're panicking and making decisions under pressure. Be polite, be calm, do not argue, do not raise your voice, and absolutely do not physically interfere with what he's doing. You'll be assaulting a police officer then. Just state your position and let the legal process do its job. Here's the other side of the coin, what not to say. This is just as important as knowing what to say. Do not say whose drugs these are or are not. When officers find something in your car, the first question they will ask is, Whose is this? This feels like a simple question, right? Well, it is not. It is an invitation to incriminate yourself or someone else. If you say, those aren't mine, you have just confirmed that the drugs are present, and you've begun a conversation about ownership. In court, what you say can be used against you. What you don't say cannot. So, do not explain where the drugs come from. Do not say, I was holding them for somebody else. Do not say, I forgot those were in there. Do not say, those must have been left by my body last week. Do not say anything at all about the drugs. The legal framework here is the Fifth Amendment. You have the right not to incriminate yourself. That right exists at a traffic stop just as it exists in a courtroom. Use it. You're not required to help them build a case against you. And you cannot talk your way out of a drug arrest. Remember what I said. You cannot talk your way out of a drug arrest. So don't even try. What you can do is talk your way into a conviction. I've seen dozens. Here's a scenario a lot of people don't think about until it's too late. The passengers, right? You've got passengers in the car with you. Officers find drugs. Now everyone in the vehicle is being looked at. Under California law, the prosecution can attempt to charge multiple people in a vehicle if drugs are found in a shared place. This is called constructive possession. You don't have to physically have the drugs in your body. If they were accessible to you in the center console, under the seat, in the back seat area, prosecutors can argue that you had knowledge of and control over those drugs. This gets especially complicated when drugs are found in a location that multiple occupants could have accessed. The advice here is the same for every single person in the vehicle. Say nothing. Do not try to coordinate stories on the side of the road. Do not try to take blame or shift blame out of loyalty or panic or anything of that nature. Exercise your right to remain silent. Request an attorney and let a lawyer sort out the questions of who knew what and when and who had access to what. Now, what happens after an arrest? Well, if you're arrested for drug possession in California, here's what changed in 2014. Simple possession of most controlled substances was reclassified from a felony to a misdemeanor. This is very significant. For many people, a first-time drug possession charge in California is not the automatic career-ending felony conviction that it used to be. However, this does not apply if officers believe the drugs were in possession for sale, or if you're charged with transportation or distribution. If officers find a large quantity, packaging material, multiple baggies, a scale, or significant cash alongside the drugs, the charge changes dramatically and immediately. You're no longer looking at a misdemeanor. You're looking at felony charges with real prison time. And if the investigation has any federal dimension, whether the drugs cross state lines, whether there's any connection to a larger federal inquiry, you are now dealing with federal charges. Federal sentences are mandatory. There is no parole in the federal prison system. 85% of your sentence is time you will serve. This is a completely different situation, and it requires a completely different defense. What happens in the first few minutes of a traffic stop shapes everything that comes after. Officers are trained to get you talking. The more you say, the more they have to work with. You're not going to talk your way out of a drug arrest, remember that. But you can absolutely talk your way into a conviction. Know your rights. Use your rights. And if you find yourself in this situation, call a criminal defense attorney immediately. Not after you've answered a few questions, not after you try to explain yourself. Immediately. If you or someone you know have been stopped with drugs in the car in California, the very first call needs to be to a lawyer, not to a family member and not to a friend. Call my office at DG Law. The consultation is absolutely free. Drop a comment below telling me where you were pulled over and subscribe to the channel, because next week I'm covering what happens after you get arrested on your first offense, DUI.